John Bingham, a man now much lost to memory, not forgotten, not much remembered, but he was really the James Madison of the 14th Amendment because he was the one who actually wrote the 14th Amendment. John Bingham, he said much the same, he made much the same point. He said, "I am perfectly confident that the provisions of this proposed amendment would have been in the original Constitution, but for the fact that their insertion would have been utterly incompatible with the existence of slavery in any state." So the 13th Amendment prohibited slavery in the United States, and the text of that is down here, item F on your sheet. The 13th Amendment prohibiting slavery removed the source, the chief source of the lack of adequate rights protecting in the states, but by itself, it did not supply all the rights protection that Madison, for example, thought was needed. It soon became clear that freeing the slaves was not enough. Shortly after the 13th Amendment went into effect, the southern states enacted laws called black codes. These so-called black codes were laws that set special limitations and boundaries and burdens on the newly freed slaves. For example, these laws forbade the ex-slaves from living in town. It required them to have a white person as a sponsor. It often required them to sign long-term labor contracts, which were very unfavorable to them, and so on. I could go into much greater detail than that. Now, Congress, when they found out about this, got really irritated, and they attempted to negate these black codes in a law passed called the Civil Rights Act of 1866, a very important piece of legislation. That Civil Rights Act was ostensibly passed under the authority of the 13th Amendment. And in many ways, this law, the congressional law, operated like Madison's negative would have. Because here's a case where the states had passed some laws that Congress thought were unjust and wrong, and Congress, in effect, negatived them. They passed a law saying, no, those laws are no good. And so that was a kind of example of what Madison would have had in mind with his negative. Nonetheless, very much and very reasonable uncertainty persisted over whether the Civil Rights Act was actually constitutional under the 13th Amendment. Because the 13th Amendment prohibits slavery, and it does not seem that the practices mandated in the black codes, bad as they were, amounted to slavery. So it was not clear that the 13th Amendment could authorize this kind of corrective federal measure that the Civil Rights Act was. So thus it was that the 14th Amendment came on the scene. The 14th Amendment attempted to do more adequately what the 13th Amendment had attempted to do, and that is to reorder the original constitutional ordering of rights and federalism. Now, we can best discern the 14th Amendment's effort to complete the Constitution by comparing an important rough draft of that amendment with the final language of the amendment as it was adopted. And here, please bear with me because we're going to have to go down into the weeds a little bit and look at the language pretty closely. And I have tried to make that easier for you by giving you a handout that has all that language on it. So the rough draft, which is item G on the handout, says, just I'm sure you can read it, but we'll read it all together. The Congress shall have power to make all laws necessary and proper, first, to secure to citizens of each state all the privileges and immunities of citizens in the several states, and then second, and to secure to all persons in the several states equal protection in the rights of life, liberty, and property. Now you might notice, just casual observation without seriously studying it, that there's a lot of overlap between the language of this version, what I call the February draft. It was introduced in February 1866. A lot of language overlap between the February draft and the final amendment, but there are very significant differences as well, and I want to spend some time talking about those differences. So the first difference, and I think the most striking one, is this. The February draft is an empowerment of Congress to do certain things, whereas the final amendment is a prohibition against the states doing certain things. Okay, that's the most obvious, and I think in a way a very, very important change. But I want to focus attention first on another change, another difference between them. The final version, again, remember, it's the first item on your sheet, so you might refer back to that if you want to. The final version contains three sets of protections. Protection for privileges and immunities, a due process of law requirement, and an equal protection of the law's requirement. But the draft, this February draft, contains two sets of protections. On the one hand, privileges and immunities, that's similar, and on the other, what is called equal protection in the rights of life, liberty, and property. I want to focus attention on that second part first. Now, the second of these two clauses provides protection for what? The familiar triad of rights, life, liberty, and property. That is to say, the triad of natural rights. In effect, it says, the February draft says, Congress shall have the power to protect the natural rights of persons. The second clause, then, would seem to see to it that all persons receive protection in their natural rights by empowering Congress to provide it. In the final version, the language of this draft clause has been split, though, into two clauses. Again, I'll read it to you. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, my claim is that the due process clause and the equal protection clause, as in the final amendment, are directly descended from the equal protection clause in the earlier draft. The principle responsible for the change from one clause to two clauses, in effect, the principle responsible for that change is easy to see, I think, and that is because the earlier version empowered Congress to see to the provision of equal protection of these natural rights, but the final version instead makes this into a prohibition against the states failing to secure persons and their natural rights. Okay, so we have a shift. In one case, Congress is empowered to provide protection for the natural rights. In the other case, the states are now forbidden to interfere with or deny these natural rights. Now, to understand the nature of the bifurcation, the way in which one clause becomes two, we have to understand that there are two different ways, and only two ways. This is completely exhaustive. There are two ways, and only two ways, in which states can fail to secure natural rights. And I've listed those out on item number H on the sheet. First off, a state may itself threaten rights. It may threaten rights by depriving persons of those objects to which they have rights. The government may come and take your property without, just take your property, or may come and throw you in jail for no good reason. So if government seizes your life, liberty, or property, that's a way in which it jeopardizes your rights. But it is, after all, the business of governments to apply coercion against states who violate legitimate laws, and therefore states don't threaten rights every time they do that. They only threaten rights, or illegitimately threaten rights, only when they deprive persons of those objects of rights outside the law. That is to say, without due process of law. That is, without proper legal authorization and without proper legal process. The Due Process Clause, therefore, provides a part of the protection to natural rights originally contemplated in the second part of the original draft. That is, protection against unwarranted deprivation of rights by the states themselves. But states are not the only agents capable of depriving people of rights. The business of government, after all, is to supply protection for rights against other individuals, against the action of other individuals. So we have laws to protect you from other people coming and stealing your property, for example. That's the business of the state, is to provide protection for your property, i.e. protect your right to property by prohibiting and then enforcing the prohibition against private persons. Supply protection for rights or supplies some persons quite inferior protection, it is failing in its primary duty of rights protection. Thus, the Equal Protection Clause of the Final Amendment forbids states from denying rights by failing to provide protection. Okay, it's a little complicated. Is that relatively clear? We can pursue it in the Q&A after if it's not, but I hope it is. So tracing the modification of the two texts through the two drafts of the 14th Amendment leads to this conclusion that the two clauses, the due process and the equal protection clauses, are devoted to the protection of natural rights of persons against the states in the two different ways in which states can deprive persons of those rights. Prior to the 13th and the 14th Amendments, these rights had no constitutional status vis-a-vis the states. The original Constitution took it for granted that the states have the chief responsibility for supplying protection to these natural rights, but with a few exceptions, the Constitution placed no restrictions and placed no duties on the states in their dealing with these rights. The 14th Amendment works, therefore, a major shift. Under its terms, all persons within the United States now have a federal constitutional right to have their natural rights protected by their states. That's a big shift. The 14th Amendment, though, does not transfer general custody, legal custody of these rights to the federal government, however. The states are to remain the main government agency dealing with rights, but limitations are now defined that the states must respect on pain of being corrected by agents of the federal government. Okay, so this is a kind of corrective federalism.